Tonight is not just about education. It's not going to be a monologue. We really want it to be a dialogue, a conversation. So feel free at a certain point to ask questions, to pick the brains of the panelists. That is why we have tapped on them to donate their services on tonight. Okay, so if you have questions, please feel free to write them down. And if you don't feel comfortable asking, just kind of wave at me and I'll come grab them and ask on your behalf. Okay? With that said, let me go ahead and do some quick introductions. All the way to my left, your right, is Mr. Jim Behringer, who will be discussing all of the information related to titles, okay? And the ins and outs related to titles. He will give you more in-depth information when his time comes. We have Mr. Chris Kirby of the Bastrop Law Group, and Dominica McInness, also at the Bastrop Law Group, who will talk to you about property, deeding, et cetera, et cetera. We're going to do a deep dive, well, a 30,000-foot deep dive, okay? But don't worry, we have a parachute, all right? We're going to dive into some really, really good things on tonight, all right? So let me put the framework out there so we kind of know what we're working with before I pass it off to the panelists. In all of our lives, there is a word that you don't hear much, but it means a lot, and that word is legacy, okay? And you have to ask yourself at some point, what legacy are you leaving behind? And when we're talking about it from a tangible standpoint, i.e. land, houses, et cetera, things that you've acquired in your lifetime that we obviously can't take with us, are we doing it in a way that is secured for those that we're leaving behind? Okay? And tonight we're going to explore all of those things and the nuances that come up in that space. So without further ado, I will pass it off to our panelists who will kind of give you a brief introduction about what they do on their day-to-day. All right, and we'll jump into this conversation. How does that sound?
All right.
All right.
Hello, everybody. Can you hear me okay?
Yeah.
My name is Jim Behringer. I'm with Independence Title. I'm the marketing rep for Independence Title in Bastrop County. So we cover Bastrop, Smithfield, and Elgin. Independence Title is a very large company. We're the largest title company in the greater Austin area. We're in Dallas, Fort Worth, Houston, and San Antonio. And so we're trying to be part of that organization. Tonight, they called me. I appreciate you all asking me to come in tonight to just kind of be here to give my perspective of what the role of the title company is in a real estate transaction. And most people, including me, when I got in the industry, just thought that's where you close, you sign the paperwork, you pick up the keys, and you get your house. But there's really a lot more to it than that. We have some major roles that we perform, especially on the front end. The two things that we really check for when we first get a contract in from a real estate agent, or if you're not using a real estate agent, is we check to make sure that the person that brings in the contract is legally able to sell the home. So if you live in the house and you're on the deed, you probably have a good shot at being able to sell the home. But if you inherited that home, if you have siblings or an ex-wife or things like that, you may have to check in with somebody else to get permission to sell the home. So we check for that. And the other thing that we do a lot of checking on before we say this home can go into title, can be insured, is we make sure that there's no liens or debts or for taxes or that sort of thing on the property. So those are the things that we do a really deep dive on. But to be honest with you, if it gets too heavy into either of those categories, especially when it comes to inheriting property or co-inherited property, we say you're going to need to call Chris and Dominica. So they're probably going to be doing the bulk of the presenting tonight, and I'm just here to give my 2 cents where it's appropriate. Thanks. Go ahead.
Okay, so I'm going to set the stage a little bit. I'm Dominica McInness. I'm the CEO of Bastrop Law Group, which means I run the business side. I'm not an attorney. I work with the attorney. I'm the attorney herder. It's like herding cats. But we really noticed the challenge in the Bastrop community and the greater extended Central Texas area of a lot of challenges with your estate. And Chris and I have a couple of businesses together. We've worked together for 11 years or more. And it was one of those areas where we said, how do we help protect the community? This is something that's impacting our entire community. So my role here tonight, one of the things we want to do for you tonight is we don't want it to be just education. We brought a stack of papers with us there are some common things that everyone needs. We can't do everything tonight, but we chose a couple of the most important things that we would like for you guys to at least leave with as a minimum if you don't already have them. A couple of estate planning documents. So there's going to be a part 1 to this presentation of kind of the roundtable and answering questions, and a part 2 of where we actually go, let's execute some documents or tell you about them. One part is probably going to be interesting. The second part might be a little less so, but we might play Ring Around the Rosies and have you arrange the table so that y'all can help witness for each other. We're going to get this done. I brought my notary stamp. And so you'll walk out with some executed documents tonight. And then, so I'll turn it over to Chris, who's going to explain what those documents are a little bit. We'll take your questions and go for the rest of the night.
Cool. So my name is Chris Kirby, and for the last 35 years, I've been practicing law, predominantly estate planning, real estate, and probate and guardianship. So the stuff that we're talking about tonight. Does the mic catch me okay? Yeah, okay, good. So what I want to do is talk to you a little bit about what it means to deal with your estate. And most people think about that as, do I get a will, right, or not? But the reality is that in this day and age, the vast majority of us do not, go take a nap and not wake up and fall into the arms of Jesus. And the reality is that for a lot of us, we really need to be set up for what's going to happen in the event that we are unable to take care of ourselves, or we're unable to take care of our things before we pass away. And sadly, over the last 35 years, and we'll talk about some of those war stories, a lot of my practice involves folks who, for whatever reason or no reason at all, did not get themselves situated properly to take care of themselves up to the point of passing, and then to take care of what happens with all of your stuff, because the old saying is, you can't take it with you, right? What happens with your stuff after you pass. Also, to Jim's point, the reality is that Bastrop County is filled with folks who did a great job of hanging on, acquiring and holding on to land through a lot of challenges, through unimaginable challenges, only to see that land go away because it wasn't transferred properly. And by that, what I mean is, the way that land passes between generations is through two things: deeds and wills. And so, when you pass away, you say, Jim gets this and Judy gets that. That goes through a will. Or prior to passing away, you're deeding it to your children or whatever. And by the way, that's not a great idea from a tax perspective, and I'll talk about why that is as we go along. But nonetheless, somehow that land transfers. And if it doesn't do so properly, then when it gets to the title company, on Schedule C of the title, it's going to show all of the stuff that I get to fix. And that can be easy, or like a file that we have in our office right now, it has not been transferred properly for multiple generations. And so far, we've identified 108 co-owners to a piece of property. And so you can imagine what a nightmare that is. Not only that, but one of those people thought that he owned it all these years, and now he finds out that when it sells, he's going to split that between 107 of his cousins, second cousins, and everybody else. Okay, so transferring property seems easy. When I pass, my wife gets it, right? Maybe, maybe not. When we pass, our kids get it. Maybe, maybe not. And that's the sort of thing that we want to talk about, because the fixes are easy, but you need to understand what the problems and questions are before you get to them.
So I'm going to facilitate a little bit, if that's okay, Eric. One of the things before we go through, we'd like to hear from you. Eric said it's not going to be kind of a monologue. Are there any questions or particular things that you guys would want to hear addressed tonight about related to your estate or estate planning, so that we can keep that in mind as we're just talking? Does anyone have anything particular? And I know, yep, go hand.
Yes, ma'am. Oh, and be forewarned, I did way too much shooting without ear protection, so I'm deaf. So make sure and make it loud.
Just kind of, for instance, my mom just had a health issue that made us think ahead in the future that eventually, sadly, she may end up having to go to a nursing home. My dad's passed. And If the year started that, if she ever has to go, she can find that started, she's creating a policy for assets.
Right.
If she ever has to go to the bank, she can't afford the other thing, oh, the next thing in bank.
Correct.
And the four stories that I've heard from my tested family banking hates all of your assets.
That's correct.
So that's what I'm trying to prevent.
Right.
They have my parents' legacy eventually go down to them.
So, okay, go ahead.
We're capturing
Yeah.
them. We're not going to answer it now, but we're
I
capturing.
promise, yeah. And if I don't, then we can talk it.
I was going to tell that I couldn't tell what she was describing. If it's possible, we also speak to Lady Murphy.
Sure. There are actually two kinds of deeds like that. One's called the Ladybird. The other is called the transfer on death deed, and we can start to talk about it.
And funny enough, I took it out of the container and I was like, we don't need to go that deep tonight. Transfer on
Yeah.
one.
Yes.
Trust funds, pros and cons possibly.
Okay.
Let's understand there's a lot of things.
Trusts are not tax deferred instruments. That's one of those things that people think, and so we can talk about them versus wills. Yeah.
Because you hear a lot of that on social media and it works differently in Texas.
Yeah. Yes, ma'am.
I'm with him. I'm being trust versus
Okay. Sure. a lot of folks are interested in trust. Good.
I actually said my mom's probably in 35, and told that was the easiest way to try to make sure her copy was second. So that, I would like to come.
Good. Okay.
Second, I'm not sure if the recording can hear what the questions are in the back.
Oh, okay.
We can
So
repeat them.
yeah. So
Repeat them.
the questions you want to click off the
So
questions so far?
the topics so far have been, kind of addressing mom and nursing home and protecting assets for Medicaid and, what to do about that. Addressing labor deeds, transfer on death deeds, and trust versus wills when you need all of those different instruments. And we're going to give a high-level overview of those in addition to, some other things, I'm sure.
Yeah.
So keep your questions coming.
Yes, ma'am.
everything you're discussing tonight, it pertains to Texas overall, no matter what county.
Correct. Yeah. Now, does anybody own property outside of Texas?
The court, let me say this for the recording. She asked if everything that we are addressing tonight pertains to Texas, and the answer is yes.
Yeah. So all estate planning is state specific. So there are two components to it, really. There's the state stuff, and then there's the federal stuff, right? And really, on the federal level, it only pertains to if you have enough money that you might pay a death tax. How many of y'all think that you need to worry about paying taxes at your death just because you died in estate tax?
What kind of money you talking
Yeah. So a lot of folks are like, when I die, the Fed's going to take a chunk of it, right? And the truth is that this year, the only way that would apply is if your gross estate, that means the value of your dirt, the value of your house, the value of your car, the stuff in the bank, everything put in one big bucket in value is over $13 million. Okay? If you're not worth that much, you do not need to worry about estate tax. Okay? Now, in 26, that drops back. So then it might apply to some of you if you're worth more than $5 million. Okay? But if we use some planning, we can expand that to 10 real quickly. So the moral of the story is the vast majority of us have the fortunate/unfortunate problem. We are not worth enough to worry about death tax, and you do not have to plan against that, even though when you're watching TV and you see the things about get a trust, they always say avoid estate tax. You don't need to worry about it. And Texas does not have an estate tax. Many states do. Most of the states you think about, New York, New Jersey, places like that, do have a death tax. We do not. Yes, ma'am.
Does that apply to the person who inherits the property? I mean, I understand if I had this amount of money that it was.
So the tax is paid by the estate before the question was, does it apply to the person who inherits? And what happens is the estate pays the tax, and what's left is given to the person who's inheriting. But again, unless someone is worth, a lot of zeros, they don't need to worry about it. Yes, sir.
I have the same question. Is there a limit on the money that you inherit?
No. Elon Musk is going to give his kids a whole lot of money.
So the cards, how much you inherit, get out here.
No. Here's how it works. until you reach the limit, in this case, this year, 13 million, okay? There is no tax. Over that, there is a tax. And obviously at that point, you really need to be talking to me to minimize that tax as much as possible. I will say, for those of you who own property in Bastrop, significant property in Bastrop, a lot of us have been here a long time. Like when we thought $3,000 an acre was insane and I wouldn't pay that much money, right? In South County, no land right now is going in South County for less than $50,000 an acre, okay? And so you need to realize that, you know, your land is worth a lot more than you think if you've been on it a long time. Other questions? Yes, ma'am.
About capital gains, yeah.
Capital gains is a great question, and we'll talk about that. That's when you sell property. You pay a different tax than income tax. You pay a capital gains tax, and I'll talk about that if Jim can. So, any other questions before we kind of dive in?
I have one on behalf of the audience and
Okay.
myself. It's true for us, for attorneys, that it pertains to Texas. What about for title? Is it very state specific?
Yes, yeah, and so we'll be talking only about Texas as well.
Okay. All right. So, yes, ma'am.
I do have one question. I don't know if it applies yet, but just in my head. If you have a will, written a will up, do you have to have it registered somewhere in Texas?
No. The question was,
Yes.
the question was whether or not once you write a will, do you have to like file it somewhere or register it? And the answer is no. After you pass away, whoever you name as the executor, who's the person who's going to deal with all your stuff, they will bring it to us, and then we will file that along with the death certificate to institute probate. And we'll talk about that in a minute too. And by the way, that's another thing that everybody, you know, the advertisements are like, avoid probate, you know, and probate's so horrible. If you're in Florida, absolutely true. Illinois, avoid it like the plague. New York, stay away from it like in any way you can. California, the same. Texas, probate is super easy. And you keep in mind when you hear this, you know, in lawyer speak, it is inexpensive. There's no reason to avoid probate in Texas. There are some reasons, but not cost. It's really easy, it's really cheap, it's really quick. So let's talk a little bit about tonight. So let's see, I can't read it. A high-level overview of the issues. They've got a little screen here for me, but
It's far away.
let's see if these help. Nope, not a bit. Okay, so provide relevant information and encourage, you know, action. And that is one thing I will say. If you guys spend the next couple hours sitting here listening to this and don't do anything with it, then obviously you wasted your time. But more importantly, you put your family in a terrible place. Not planning puts your family, your loved ones, in an incredibly difficult position at the worst possible time. You don't want a family member sitting in the waiting room of a hospital with no power to make decisions over your health when the doctor is sitting there saying, we need to decide. You do not want to have your family members watching your money fritter away because some crook is taking it from them and have no power to do anything about it.
And we're going to talk about some of the horror stories. 'Cause
Yeah.
this
They are
does
real.
happen.
I do a lot of work for APS, Adult Protective Services. When the worst things happen, they bring them to me, and I do guardianships for them. They're very expensive, they're very difficult, and they're 100% unnecessary. Let's see, protect your family and our community, absolutely. So,
That's our goal for tonight. We want to protect your family and protect your stuff.
yeah. You worked hard to get it, you ought to decide where to send
There's
it.
a question here.
Oh, yes, ma'am.
Power attorney is on medical. Then the two type of power attorney, medical is only ones to make the decision about your health.
That's correct.
And there's no real ask questions about.
And the last part was what?
It has done good once they.
Oh, that's right. There are two powers of attorney that you need, and we'll talk about both of them tonight. One is the medical power of attorney, and if you stay till the end, then you'll walk out with an executed, valid medical power of attorney for you. Okay? And the other is called a durable power of attorney, and the medical power of attorney is for your medical decisions, right?
Yeah.
What happens if you can't decide? And the durable power of attorney is to make decisions about your stuff. Who can sign your tax return? Who can deal with your bank accounts? Who can buy and sell your home? Those kinds of things. Okay, and so you need both of those, and we'll talk about both of them. Ancillary documents is everything except a will or a trust. Okay? And so a durable power of attorney, there are two kinds. One is called a springing durable power of attorney. A lot of people worry that if they get a durable power of attorney, then the person they named as their agent can now suddenly run down to the bank and drain the bank account, sell the house from under them, God knows what, right? And so you absolutely have to trust the person you named as your agent, right? But with what's called a springing durable power of attorney, what it means is it's not worth the paper it's written on until it springs into force. And when does that happen? That happens when you are diagnosed by a physician who's trained to do it to be mentally incapable of handling your own affairs. Okay? Until then, the person named, if I name Dominica, pardon me, is my agent under the power of attorney. And so once she's empowered to do so, she can do a lot. They're very, very powerful. But at least most people think currently I'm not mentally incapacitated, although she may argue a couple of times a day while we're at the office. So until I am diagnosed by a physician to be mentally incapacitated, the durable power of attorney is not useful for anybody for anything. So you don't need to worry about it if you have springing durable power of attorney. For some who've been married for half a century, whatever the case may be, everything they own is in both people's names anyway, etc., you might want what's called an immediate power of attorney. Or if, let's say, your spouse is unfortunately sliding into dementia but still is capable right now, that spouse may sign that power of attorney because they know. It's not if, it's when you're the agent, the husband or wife who's not suffering from dementia is going to need to step in and help. So why go through the extra step of having to be diagnosed, right? Durable power of attorney.
Can we pause there?
Yeah.
Okay, so another aspect of my role is to turn this into civilian language. And one of the biggest things we see, one of the biggest challenges we see in the community is waiting too late to get that durable power of attorney. The slow slide into dementia, they wait until that person is no longer
Able to sign.
ethically able to sign. They might be able to sign their name, but then an attorney or a doctor is going to go, no, they're not really capable of making these decisions. And so the biggest takeaway, don't wait too late.
Yeah, exactly. I mean, my in-laws, my mother-in-law died of vascular dementia, which is basically Alzheimer's by a different name. 42 years in marriage, my father-in-law could not bring himself to put her in front of a doctor and have her diagnosed. And she did not want to sign one because at that point in her slide into dementia, she was paranoid about him stealing her stuff. Half the day she didn't recognize who he was. And as a result, they didn't file a tax return. They didn't register the car. He couldn't do anything that was jointly held for the 3 years that it took between her really losing capacity and passing away. It was a tremendous mess that could have been avoided.
It is the future, when it was time for him to pass, and he has, the kid said, please don't do this to us again, basically, and made sure that he had the right documents.
Done while he was capable of
And,
doing it.
and this was totally accessible to him, obviously.
Yeah, I mean, 30 years, he had plenty of time.
Right. Well, and a son-in-law, but half the time it's not the money that stops us; it's the courage. It's the courage to make those tough decisions and have those tough conversations. And so, what we want to, share with you is that we see the other side of not doing that. Please have the courage to make those tough decisions and have those tough conversations.
Yeah, I want to skip a couple of bullets down to the Declaration of Guardianship. And this is one of those places where I'll make a shameless plug for estate planning attorneys. Every attorney who's licensed will write a will and do the things that are sort of on the cliff notes of doing things. But it's really important and very often not done by those who don't do this a lot to get what's called the Declaration of Guardianship. Now, if you have minor kids, you need to have a declaration of guardianship for them. Like if husband and wife go to the restaurant at night and get hit by the milk truck on the way home, who's going to raise the kids, right? And so you need one of those if you have minor children. But this declaration of guardianship that you see on the screen is not for your kids, it's for you. And so, for example, everybody remember the big freeze? Right after the big freeze, I got a call from Adult Protective Services. They asked me to take the case of a 81-year-old retired school teacher from Elgin. She'd been married, had no children, and her husband had passed away. She was sliding into dementia. She did have powers of attorney with a great niece who lived in Temple, so they weren't in constant contact. A 47-year-old boyfriend showed up and got her to sign new powers of attorney. Well, who can decide if she had capacity or not, right? And so the assumption is that she does. So that new boyfriend proceeded to start draining her bank accounts. He moved her out of her house into the RV in the yard so that him and his meth addict buddies could take over the house. He moved her out of the RV in the yard into her car so that he could put a prostitute in the RV to pay for the meth for him and his buddies. And then the big freeze hit. She spent the entire big freeze in the car, not eating. And when the freeze was over and thawed out, she went to a food pantry. They called Adult Protective Services. Adult Protective Services called me. Okay? At this point, that guy has every legal right with those powers of attorney to drain a bank, to sell her house, to do anything he wants with her because he's got a medical power of attorney on her also. And so then the fight was on. Okay? I represented the great niece and trying to get a guardianship over her, which is exactly the same power as those powers of attorney, but it's done by the court. The court says you are in charge of her medical decisions, you're in charge of her life. Well, guess what? Her estate, her money, her bank account was paying me. Her bank account was also paying the lawyer for the bad guy. Okay? And so a total of close to $50,000 in legal fees later, he's in jail. We got her house back. We got her RV back. She's not in the car, but that $100,000 went in a lot of people's veins. Okay? That's what happens without powers of attorney. And that's also the reason that we do declarations of guardianship, because what that document says is, if I ever need a guardian, which is highly unlikely for most of us, but if I ever need a guardian, this is who I want to be the guardian of my person, just like the medical power of attorney. This is who I want to be the guardian of my estate, just like the durable power of attorney. Typically, it's the same person. Then what would have happened in that situation with this woman in Elgin? If she had that document, I would have walked into Ben Neskew's court and I would have said, Judge Eskew, this is who she named as her guardian when no one argued whether she was competent. And he would have looked at the bad guy and said, is your name Judy Jones? And the guy would say, no. And he'd say, then you're gone. Judy is the guardian. That's it. It's over. Okay? And we probably would have saved her, at least 20, 30, 40,000 bucks, a whole lot of time, a whole lot of headache, a whole lot of pain. Okay? So that's why you need that document. Because on the very unlikely chance that you ever need a guardian, it makes it really, really easy. But if that unlikely chance ever happens and you don't have that document, then the pain is immense. Okay? Yes, ma'am.
I just want to clarify, you have to have a court issue guardianship.
Guardianships are issued by the court. Powers of attorney or not. We do those. We'll do one tonight. We'll do the durable power if you come to my office.
Can you explain why?
Because the court has to decide. The question was, are guardianships done by the court?
I think, let me clarify just a second. You get to fill out a form to declare who your guardianship is. If you don't, that's when the courts decide, if needed.
Okay, so
Yeah.
we can assign that
You can.
without having to go through
Right.
court. Thank you.
And
That's what I
the
needed.
difference is, these documents, this ancillary document is $150 roughly
piece.
a piece. So $150 to sign a declaration of guardianship versus if you ever needed guardianship and you didn't have that, $5,000 to $30,000. And so we much rather just go ahead and get that done ahead of time.
Right. And yes, sir.
I had a question about the durable power, medical power of attorney, which I had when my mother had dementia. At what point can I call as two sides to beg the wrestler?
So the question was, when are the powers of attorney used?
Yeah.
And typically that's a pretty easy determination, right? The person's under anesthesia, they're in a coma, that sort of thing for the medical power of attorney. In the case of a durable power of attorney, if it's a springing durable power of attorney, in other words, it only goes into force when you're incapacitated, when you can't make your own decisions, a doctor has sat you down, run you through a battery of tests, looked at you and said, sir, I'm sorry, but Jim over here, who's your agent under that power of attorney, is now going to be assisting you with making this decision. Is it an all or nothing? No. I mean, obviously, it's like if someone is slipping but not completely incapacitated, not making any decisions at all, and, they're going to help you figure out which car they'd like to be riding in. They just don't get to drive it. Does that make sense? Yeah.
If the doctors would deal with me in terms of sliding a check, relaying information, mom just being there to retain,
Yeah.
somewhat would help.
Right. The moments of lucidity is the way we talk about it. And so you'll sign, oftentimes you'll sign on her bank account, but you'll sign it Chris Kirby, agent for Helen Kirby, or whatever the case may be. So that's other questions. Yes, ma'am.
I'm a person who spends power time and laying on hospital.
So in other words, it's like your mother, and you're the agent on it, so you're signing for her, and she goes to hospice.
Yeah, the age that.
Or the person who's the agent goes to hospice. Then both medical and durable powers of attorney have successors. So it's like I name Dominica first, and if she's not available, Jim, and so forth. So you'd have one and then another named in the document, so that if one person is not available to be your agent that you've named, 10, 15 years ago when you made the durable power of attorney, then you have someone else named in the document. Yes, ma'am.
What about the declaration of guardianship that you talked about lost right? I know that the durable power tree and the power tree end up forming combined of this particle. Is that the same for the declaration of guardianship?
I don't know, but I will tell you that if you get a durable power of attorney as an example from the Secretary of State, there are critical powers that are not included in that document. Like, for example, an agent being able to sign on a closing. If they went over to independence title, you couldn't sell property with the statutory form. Another example is like a home equity loan. If for some reason you wanted to borrow against the home of the principal, the person who executed the power of attorney and made you the agent, the statutory form does not allow for that. And so the form that we've generated over 30 years ago, and even since it's not there, has the various specifically delineated powers that allows the agent to do what the agent needs to do to take care of the person who's named in the document. So another example is to create a trust, for example, and we'll talk about that on Medicaid. You can create a trust to try to protect assets against Medicaid, but the statutory form doesn't have that specific power enumerated, and so you can't do it. It's better than nothing, no question, but there are shortfalls in the statutory form that you should have, or I think you certainly should have.
This number didn't think I'm off the state part. Probably do that.
Yeah, you have to specifically state it. Yeah, there are a number of, and the form that I've got looks a lot like it because it's got all the check boxes. Now, I always tell people I hate this form, but as an old colleague of mine used to say, you don't want the bank dissecting your durable power of attorney like a frog in freshman biology class, so you give them something they're used to looking at. But it does have specifically enumerated powers that are not included. But you can get them there, yeah. I don't know about a declaration of guardianship. I don't know if there's one there or not. Yes, ma'am.
What do you do if you don't have anybody to step in and do these things for you? You're planning for yourself, but are there?
So you don't have any trusted neighbors or anything like that?
Well, I'm just kind of putting it out there.
Yeah. Well, sadly, the
I
question
think that's-
is, what do you do if you don't have anybody to name as an agent? And the unfortunate reality is that I never saw that when I started practicing law in 1990, ever. Never saw it. But we have an increasingly isolated society. The kids are gone, they're off in other states, they're you don't have a great relationship with them, whatever the case may be. And there aren't people to name in those situations, and it's really a difficult situation. I had a client who literally had no one that she could name to take on any role, and unfortunately, I can't fix that problem. That's when I would really strongly suggest that they find a church community group, a senior center, at some place to build relationships. Now, I wish I had a better answer.
So the next question is, she doesn't have it one and doesn't finding one, does it both say?
No, so that's the question about probate that we might just make a note of. What happens if everybody you want to give your stuff to is there's nobody to give it to? Or, and that's sort of the second question to what happens if you aren't able to care for yourself and you don't have anyone you trust to make decisions for you. There are professional services. Helping Hands is one that can be hired to take on those roles, but obviously that's spending a chunk of your money. So let's talk about the third document in that list there. It's HIPAA release. That stands for the Health Insurance Portability and Accountability Act. It's a federal law that was passed probably 20 years ago, and every time you go to the doctor, you sign a HIPAA release that says the doctor can share all your documents with the insurance company. This one, you will, if you stick around tonight, you'll execute one of these for yourself and take it with you. But this one will have two things that we're going to leave blank. One is the name of the doctor who's going to provide the information, and the second one is the name of the person who's going to get the information. Because we won't know at this point if the first person you name in your medical power of attorney is going to be there to be your agent, or is it going to be a successor? So in my case, is it going to be my oldest son or my second son, as an example, okay? And so you'll execute what amounts to a blank HIPAA release, and you'll sign it and leave the date blank, because then if my son is in the waiting room and he's talking to a doctor and he says, "Can I see the MRI? I want to see if the dude ever had a brain," or whatever the case may be, right? Then if the doc says, "Well, do you have a HIPAA release?" he'll go, "Hang on just 1 second. He'll fill in the doctor's name, he'll fill in his name, he'll put a date on it, of course a copy, not the original. He'll hand it to the doctor, he'll see the MRI. Okay?
Let me say a word here, because oftentimes we think of this as we get older, but I also want to encourage you to think of this as kids go off to college or grandkids go off to college, wherever they may be, because they turn 18.
You can't make decisions anymore.
You don't get to make decisions anymore. And so I had a doctor recently get in an accident, and he's like, "Oh, we need those documents." So it's not just for older adults as they're starting to think about this, but also as the independent adults need this as well.
Yeah, I would strongly encourage you as a high school graduation present and basically tell them, "You want me to pay for college, you're going to sign this daggum document." It is medical and durable power of attorney naming you as the person who can make decisions if they get hit or if they have some accident. Because otherwise, who's going to make the decisions? I'm backing back first.
This is not about the abusive or the hero out here. I was in this case where I took it to my case, and I wanted to make the sort of people that my the hearing, and they want the original. They would say about.
They would have made a copy. Don't ever give them the original. And is that a local bank?
Austin,
Yeah, well,
Nashville.
yeah, and not surprising, but they would have taken it, made a copy, and given it back to you. Otherwise, I mean, I've never heard of a bank requiring a single original document. We don't do multiple durable powers. That's unusual. Yes, sir. And by the way, I'm sorry for those watching. The question was, a bank had asked for or demanded the original durable power of attorney.
Well, you mentioned that he would sign a copy and give it to him. So now would that mean that he still has a blank copy that he could do it again, or a different person?
He would take the original, make a copy, because HIPAA releases are valid if they're copied, okay? And he would make a copy, and then he'd fill in the copy and hand it to the guy.
But can that be changed? For instance, his brother needs his MRI, but his other brother that signed the copy was there. Could he sign another blank copy, give it to the doctor, and get the CT MRI?
Yeah, essentially, they could do that.
Awesome. And the other question was, and I'm probably an idiot here. I know I am actually. This language. What is going to probate mean? I'm
We'll get to that. The question is what has gone through probate mean, and I can talk through that when we get to that part. Let's get through while we're still breathing, then we'll talk about when we stop. Yeah. So yes, ma'am.
On HIPAA, do you need 2 witnesses
No.
and a notary?
No, a HIPAA release doesn't officially even require a notary, but we do notarize the HIPAA release anyway just to validate the signature. All right, so we talked about the declaration. The last one is called a directive to physicians, oftentimes called a living will. And it addresses basically 2 things, terminal illness or incurable illness. And it's terminal, yeah. And so it's basically like Lou Gehrig's on the one side and cancer on the other. And essentially what you're saying in that document, if you choose to sign one, is and by the way, this is another place where the statutory form is different. The statutory form said, that's the one you can get out of the Texas States Code. It says, if in the opinion of my treating physician, there's no reason to treat me, it's okay to stop. Well, if you're hauled into the hospital in an ambulance, your treating physician has known you for 10 minutes. Do you want that person to decide whether or not it's time to pull the plug? Okay? And so our directive to physicians says, if in the opinion of my agent under my medical power of attorney, which would then mean they got to keep me cooking until they can find that agent and that medical power, and my treating physician, and in keeping with my heartfelt religious convictions, there's no reason to continue to treat, then you can stop. It's like a get out of being sued free card for the doctors, so they'll actually do what you want them to do. Okay? Now, why the heartfelt religious convictions? For a long time, it was, candidly, I only faced that with Seventh-day Adventists who believe that if you get a blood transfusion, that's a sin. And I, whether you agree with that or not, that's not my call. I mean, that's a firmly held, heartfelt belief of theirs. Far be it from me to question it, especially at that moment in their lives. I will say to you, in the last 5 years, I've had more clients than I would have ever thought concerned about other stuff, like mRNA vaccines, and stem cell treatment, things like that, because they feel as if, whether you agree with it or not, that's an alteration to your God-given genetics, and they don't want to do it. And so they would rather pass away than have that done with or to them, okay? So it takes, like in the case of a blood transfusion, you're transfused, you leave that day, or you pass away. You see, and so that document allows the doctor to do what you in fact want them to do, and it's worth having, okay?
I want to pitch in here as well, because it also, we talk about, do you want the doctor to make a decision designed on you for 10 minutes? My daughter is a nurse, and it's often the opposite. The families are going, we don't want to see them in pain and suffering, but because there is no document saying who has the authority to make the decision, pull the plug, they keep going. And so until they might end up having to consult someone else, an attorney in the hospital.
And sometimes to horrific lengths.
Yes.
Yes.
And connected to that, does that it's similar to a DNR where I know a lot
Good
of
question.
people,
Yeah.
because my grandfather said once I'm out, I don't want to be resuscitated.
Right. The question is it similar to a DNR? DNR stands for Do Not Resuscitate Order. And I'm not, candidly, a huge fan of DNR personally, and especially if you have these other documents. And this is a good time to give you the mini sermonette, right? And as if the rest of this hasn't been one too. But when you execute these documents, you really need to sit down with the people you named who are going to take care of you when you can't. And you have to have the worst conversation you're ever going to have with them in your life, or one of anyway, to talk to them about things like, what happens if I can't drink? Do I get an IV? What happens if I can't eat? Do I get a feeding tube? Because you see, if you don't, you're going to starve or you're going to die of thirst, right? What happens if I'm in pain? Do you give me pain drugs? And these are not clear-cut decisions. I mean, none of us are going, yeah, sign me up for more pain, right? But as my agents under my medical power of attorney know, my oldest son just graduated from college in Virginia. While he was there for the last 4 years, if something had happened to me, my directive was, if my son wants to see me breathing, to say goodbye, anything that's going to keep that from happening, including pain medication, do not give it to me, okay? Now, I'm no hero. I'm not going to sign up for a bunch of pain. The second the kid comes in, says his goodbyes, before the door closes, hit me twice. I mean, but I wanted, at that point, it wasn't about me. That's my decision. Yours might be different. But for me, at that point, it's about him. If he wanted to see his father alive so he could say goodbye, if we all knew the end was inevitable, then that pain for me, in my estimation, was short-lived versus what the pain would be of his not making it home in time. But you have to talk about those things with the people you name. Do not leave them wondering. It's a horrible thing to have siblings in a waiting room of a hospital arguing over what dad or mom would have wanted, okay? And so sit down with them, talk about those things, talk about the nuances of that kind of stuff. Yes, ma'am.
Do you have anything that you could recommend? Because this office, like, you have to go to that go, a lot of the things that you can do.
Yes.
Arguing with the family, you know, I was doing it. Like, you know what, that I don't even know.
Right. So there's a ministry called Focus on the Family. I think it's family.org. That for a long time, and I haven't checked in candidly in a couple of years, used to have some fantastic brochures about end-of-life planning. And I'd go look for those. I'm sure there's plenty on the web. The right questions to answer. I think it was family.org. Back to the DNR. The reason I'm not a huge fan is because you're really putting in the hands of the ER the decision about whether or not they can get you back and keep you back. And I don't know if y'all know, about a month ago, a woman collapsed with a heart attack in Hobby Lobby. And two strangers, to each other and certainly to her, jumped on her, and that was your daughter?
My daughter was one of the girls.
Oh, and she the hero?
My daughter was here.
Oh my gosh, yeah.
She received such recognition.
Good.
And she's trying to spread the word about how important it is, where everybody can be CPR trained.
Yeah, so what happened, this woman collapsed and your daughter and another woman jumped into action and gave her CPR until the ER folks arrived, the ambulance arrived. As I understand it, they had to use the paddles on her a time or two to get her heart to start again.
My daughter continued to do the CPR throughout and doing the machine.
Right. They got her to the hospital by a star flight. One of the guys for ESD3 was saying something like 18% of people who have a heart attack in public live. Of them, only 8% of those who survive live without any form of deficit. And the woman who her daughter saved walked out of the hospital a week later, 0 deficit.
Wow.
Okay? Now with the DNR, if the ambulance folks were aware of a DNR, they'd let a guy on the floor. Okay? And so I'm not so sure that I want to give that level of power to somebody. I would rather say, if in these circumstances, this is where I am and this is where I'm going to remain, then let me go.
In that case, like, if, let's say that person had a DNR and a civilian just help her come back to life.
Good Samaritan.
Okay.
You're not going to get in trouble. The question was, if you help them back to life, are you going to get sued? And you find me anybody who's going to find somebody guilty of something like that.
Actually, I have.
Really?
And back in my dad's godfather, he was a physician, and he did a tracheotomy to help somebody, and that person sued him. That's back when doctors used to drive with their coats, and that's back home. That was a big thing, and doctors stopped driving with stethoscope and cloaks on them.
Yeah, well, unfortunately now in Texas we have what's called a Good Samaritan law, which basically says if you're trying something and now if you try something, you cut their head off, that might be different. But, actually when I was 16 years old, I saved a guy's life and he sued me too. So, oh well, I'd do it again every time. It just is what it is.
I'm gonna keep us moving.
Okay, so, so that's all of those. And then, let's see, how do I back up? Then there's last will and testament or trust, okay? And let's talk about those. So everybody knows what a will is. A will is valid in Texas, even handwritten. I have probated literally a will that was a note that said, Bill, please feed the dog, turn the lights on every night so that people think I'm home, and if I don't make it back from the hospital, it's all yours. That was a will, okay? But it's preferable to have a little more nuance than that, right? But a last will and testament gives all your stuff to whoever you want to give it to at your death. There are a couple of things that you want to think about. If you have minor kids or grandkids that you think you might want to give them stuff, then there are ways to plan around that with what's called a testamentary trust. It's not it's inside the will. It's kind of too hard to explain, but if you come see me at the office, I'll explain it to you.
And before we jump into the too hard to explain,
Okay.
sometimes I accuse him of talking like a lawyer. I'm like, wait a minute, hold on. Let's talk a little bit about, you said handwritten will, it can be done, but there are some rules around it. And so
Yeah.
we can't send you on with the will tonight. But there are certain situations that make things more complicated. We can't do it in a group setting. But
Yeah, but they are considered valid in Texas if you follow the rules, and if you don't do anything unintentional, like a law school exam question. A guy went into a hotel, handwrote a will on a piece of hotel stationery that said, Marriott at the top or whatever in print, and then committed suicide. That will is not valid. Why? Because there were printed words on the same page as handwritten words. It has to be a blank sheet of paper, no printing, things like that. Do not have to notarize a handwritten will. Okay? If you're going to get a will from what's called a fully attested will, which is one that I would draft for you, then they do have to be witnessed by at least 2 witnesses, and it's best to notarize them and best in order to be able to make them valid. Yes.
Address the handwritten. If I type it up like right now,
It's not valid.
that's what I wanted.
Unless, and the question was, if you type it up on a printer, is it a valid handwritten? Holographic is what the aim is, handwritten will, and the answer is no. Then you would have to have it fully attested, which means you'd have to have witnesses who knew that you had capacity, you were over the age of 18, it was your last will and testament, revoking all of the wills and codicils herefore executed by you, and you'd have to have those witnesses see you sign in their presence, and they'd have to sign it.
do you remember that little part at the beginning where we said we wanted to protect your family? But why, if you can handwrite a will, why do so many people take the time and money to have one done by an attorney? Because it keeps your family together. It's not kids going, that really wasn't a will. That was the last one. I'm not sure she really wrote that. All of those things.
Yeah, I had a client who was the founder of one of the 7-Eleven kind of chains. He wrote 13 handwritten wills. He cut various of his children out of various of those wills. He never destroyed them, and he didn't date them. And oh, by the way, he decided to cut jokes in them too. $5 million in legal fees later, they were still fighting. Okay, so it's a really good idea especially if you have kids who might argue, and most kids do, to worry about that.
So
We don't see the dumb of all these things here.
I'll certainly say that. You got it.
if you have a
Yeah, great idea. Thanks for mentioning
if you have a complex situation,
Yeah.
you might consider that you might need more than a handwritten will. Eric,
Yeah.
you have something for us here?
We are going to take a quick 5-minute break because they have some documents that we're going to have the opportunity to complete. So when you leave here, you actually have some protection when you walk out the door. Okay? So, or the democracy, if you guys would like to keep working, you work straight through. It's up to you. Wait a second. You vote. Good luck. All right, 5 minutes in it. We'll take a quick 5 minute. Inspections and appraisals. Okay. And we have a banking institution who will be doing a deep dive into the overarching term is financial literacy, but he's about to unpack what that really means, what that means to you, and how you can utilize it for yourself. So we're not just talking about putting money in a savings account. We're diving into all of the questions you may have now about investing, crypto, what the world and the economy is turning into. And everybody that we're bringing in, they are content subject matter experts. Okay, so you can do just like you're doing now, only with a different panel. If you have questions for this group after tonight, everybody get their business card?
Yes.
Perfect. They are available for hire. All right. But please contact them. Feel free to contact them after the conclusion of tonight. All right? All right, ladies and gentlemen, we give you, the Bastrop, or Bastrop Law Group, but before we do that, we had a question on the floor from Mr. Behringer. This is the question, okay? The analogy you gave, or the situation you gave, was I'm married, me and the ex-wife are no longer together, I die, but she's still on the title. Can she sell the house even though she does not live there?
You're gonna be referring back to the divorce decree. So whatever was said in that document is what's gonna happen. So if the wife inherited part of the house, or she got part of the house in the settlement, then that will stand. If the husband in that scenario received the entire house, then whatever his will says will be the dominant determiner of who inherits the house.
And then the second part of that question was, if a person's name is not on the title,
Okay.
but the title holder dies, but they were living in the home, but their name is not on the title, does it automatically pass, or what does that look like?
Well, if it's a spouse that's not on the title, they're going to have to sign off on the deed of trust, or the deed that they acknowledge that the home is being sold. Is that the question?
Actually, there have to be a probate.
Oh, yeah, we actually have it for you.
Yeah, we have this situation right now. Husband and wife of a long time, 5 kids. For whatever reason, the house had only husband on the deed, and then he passed away. And then, now she's in the house. And what happened there also was the Central Appraisal District figured out that husband passed. He died in 19. A few years later, they figured out that he died, and they took away the homestead exemption. So it's like, that's when you guys have really interesting work.
Right.
And unless you guys ever wonder what, title insurance is the best deal going. And anytime you buy property, I'd strongly suggest that you get a title policy, even if you have to pay for it. Usually the seller does, right?
If you've got a loan on the property, you're going to get title insurance,
Right.
because unless it's a hard money lender, which means somebody loaning it basically out of their own pocket, they're going to require that you have title insurance to protect them.
Because otherwise they're telling you there might have been a problem up the line. We have a client, for example, in Page, who bought a city block. And she thought that she was buying it from the sole owner. It turns out 1/8 of an acre, dead center in the city block, was owned by 8 different people, all of whom were dead.
Oh my God.
And so now we got to find all of their kids. And we got to get all of those kids to clean all of that up. And the title company is one that ultimately finds that kind of problem, because otherwise what happens, she buys that city block, builds a big, nice business on it, and then finds out that she's built it on somebody else's property. And that ultimately was something.
We find the problem when we say, you need to call Chris.
Yeah, so you always, title is the best deal going. One other thing I'll say about title, or ask you about is, like a 1A versus a 1B survey. You want to talk about that?
I'm not.
So typically when you get a title policy, you're going to give you a survey, right? And how many of y'all think the fence shows actually where your property line is? It doesn't. A 1B survey, which is what you typically get, and what the title company's going to ensure, ensures the general meets and bounds of the property. So that means, is the fence here, or is the fence there? And is that fence on my property, or is it on the neighbor's property, right? But if you ask the surveyor to do 1A survey, I mean, they're doing the same measurements and everything else. Now they'll certify whether or not that fence post is on your land, the neighbor's land, split in half. They'll tell you exactly where that property line is. And the thing is, a lot of times, you'll have the neighbor who's, but that fence is mine. And in fact, the property line's 10 feet in or whatever, and he's taking a piece of your land. And so you want to get a specific survey so that the title company, it's standard exclusion 1B, I think it is on Schedule B, that you exclude that exclusion. And that means that the title company will ensure the property lines split. So back to
No, usually the additional insurance on that's 5 to 10% of what a title policy costs. And the good thing about a title policy, when you're getting it, when you buy properties, it's a one-time fee. You don't pay it annually like you do other insurance. So usually, if, let's say you've got a $400,000 piece of property, title insurance is usually about $2,000, and then the survey insurance could be about an extra $100. So that's relatively affordable insurance to protect yourself there.
And the good news, if something happens when you have a title policy, they pay the lawyers. And so it's a great deal. I would never get a piece of property without a title policy.
So if you inherited land, should you go back and get a title? Can you go back and get a title policy on it?
You can go back, but the title policy from the folks that you inherited, it should protect you in that case,
Unless they didn't have one.
unless they didn't have one. But in most cases, if there's ever been a loan on the property, even if the loan's paid off, the title insurance is still good. If you inherited a piece of property and you're concerned that it may not have title insurance on it, it's not a bad idea to get it.
Yes, ma'am.
How do you protect your title? I keep hearing things about title from homes being stolen from someone that just goes online, steals your property. And we call on occasion just to make sure ours is still in our name. And is there a way, is Texas dealing with this at all? Is there
Well,
a way
that type of home title insurance that they're talking about, the question was with regard to people committing fraud and coming in and taking over title to your property. Is that something that we need to be concerned about? And 3 years ago or 4 years ago when they started advertising, I would say, no, that's not something you need to be concerned about. But we're seeing a lot of title fraud these days. We don't insure for that type of title fraud to a property just off the street, so they got those other companies that will do that. But we're seeing a lot of probably 2, 3, 4 times a week, my company is catching somebody trying to fraudulently sell property they don't own. And usually it's a lot that has out-of-state owner and taxes are delinquent or something like that. But we're catching it all the time.
So is there a way to flag your title and says, unless you hear from me with the underwriting, I come in first and or something, you can't transfer my title into someone that,
As of right now, not that I know of.
Yeah. The question was, can you flag your title so that that sort of thing won't happen? And I'm not aware of it.
Yeah. But we're not seeing a lot of people, and my disclaimer, because I'm not a lawyer, we're not seeing a lot of people that own homes have their homes stolen if they weren't involved in a real estate transaction. The title companies are very on top of the situation because we don't want to end up having to pay out either for transferring that. But it's probably not a bad idea to get the home title lock. And I think it's relatively affordable right now.
What you got it,
Home Title Lock, I think, is the company that I see that's advertising it. But it's going on, and there's a lot of fraud out in the world right now. But we're catching most of the transactions, we're catching all of the transactions that come through us because we send letters and we verify the people that we're working with are the people that we aim to work with.
Right. Yes, ma'am.
I digress. I know the question earlier on these forms, if you have somebody that witness pass away, you have successor, why not give the witnesses pass away? You have to.
So the question is, if you have an agent that passes away, what happens? And if you have a successor agent named, then it just devolves to them, goes down to them. Witnesses on documents, when we do wills and declarations of guardianship, which are the two primary documents that require witnesses, a medical power of attorney actually can either, I'm down the crap mill, you can either have witnesses or a notary on a medical will, you do both. Anyway, you do what's called an affidavit of heirship, or excuse me, I got it down blanking on my own documents, but anyway, there's an affidavit that basically is signed by the witnesses. It says the person who signed the will was the person who signed the will. And that means I do not have to go find those witnesses when we go into probate. If you don't have that affidavit, thank you, self-proving affidavit. And if you don't have a self-proving affidavit on those two documents, then I've got to go find the witnesses in probate. So let's talk about And let me talk a little bit more about last will and testament and trust real quick, because that was a question that was asked earlier.
And actually, you answered my question.
Okay?
Question is the witness passed away.
Do you have to do
Yeah.
documents?
No. If we have a self-proving affidavit, you do not have to do new documents for witnesses who die. Okay?
Before you?
Yeah, go ahead.
So I want to keep in mind that we have a hard stop at 8 o'clock. So we're going to fly through a lot of these things. I'm going to ask you to hold the rest of your questions, write them down for me. Hold the rest of your questions till the end, because we might actually answer some of your questions as we go through. So we want to have time to execute the documents.
Right. So will versus trust. Everybody hears about trusts. Do a trust to avoid probate. There's really no reason to avoid probate in Texas. So what are the reasons that you would want a trust instead of a will? And there are primarily three. Okay. First, if you're wealthy enough that you might pay a death tax. Okay. And notice in this year, that means that you, as an individual, need to be worth $13 million or more. As a couple, worth more than $26 million to think about whether or not you want to do a trust. That drops back to $5 million in 26 to 5 and 10 for individuals and couples. The second reason is if you have property outside the state of Texas and you want to avoid probate in that state. Got a client who inherited property from his father in Oregon. Oregon's probate is nightmarish. It would have been helpful if they had a trust to avoid that. Third problem that is most frequently the one that people would want a trust instead of a will for. And by the way, even if you get a trust, you're also going to have a will. It's called a pour-over will. Kind of catches anything that's not put in the trust. A trust is really just an empty bucket that you put everything you own into, and then it's distributed out of that bucket. Okay? And so the third big reason is a blended family. I would say the majority of the people that I know, unfortunately, have gone through divorce or death of a spouse. And then if you marry someone else and their children from one or both of you, now you're a blended family. And in that situation, you can't control what the surviving spouse is going to do if you pass away first. In my case, I have 3 kids. If I remarried and then I passed away first, and I gave everything to my surviving spouse, which is most of the time what we do, right? I die first, spouse gets it all, then it goes to the kids after spouse dies, right? Well, I've got a case right now where wife died first, husband promptly changed everything, and hosed the wife's kids. Okay? And there's nothing that can be done about that through a will. A trust is going to say, I pass first, my spouse gets to use all my money as long as she's alive, but then when she passes away, the stuff goes to the kids the way I want it to go, even though I may have been dead by then for 20 years. Okay? That's one good reason to have a trust. Keep in mind, trusts are significantly more expensive than wills to produce, and they do need to be managed, because now you don't own your house anymore. Your trust owns your house. Who's the owner of the trust? You are. So as a practical matter, it's exactly the same. But now my house isn't owned by Chris Kirby anymore. It's owned by the Chris Kirby Revocable Living Trust, of which I am the trustor. I created it. I'm also the trustee. I control it. But I don't own that property anymore. The trust owns the property. Okay? There is some protection in that trust against creditors, but there's also protection in a will and death against creditors as well. So, and it's not going to protect you from creditors you had before you put the stuff in the trust. As an income tax matter, it doesn't make any difference. You're going to pay exactly the same taxes in a trust as you're going to pay if you own it outright. And then likewise for capital gains tax, which was asked about earlier, capital gains is paid when you sell property. So you buy the house for $100,000, it grows to be worth $200,000 and you sell it. The capital gains tax is the tax on the difference between what you bought it for, called the basis, and your recognized gain, the amount that over that. In other words, you'd be taxed on $100,000, not at income tax rates, but at capital gains rates, which are a little bit lower. So those are kind of the differentiators. If you don't have a blended family, if you're not worth $1 bazillion, and if you don't own land outside of Texas, except for the fact that I got 2 kids, I still got to potentially put through college, which means I need all of your money and more of it, I'm going to be writing you a will instead of a trust because it's a lot cheaper. Okay? So, Wills in Texas, easy to write, easy to execute. You don't put them anywhere. Nobody sees them until you're already gone, and by then you don't care if they're pissed at you or not. Do a will, okay? Don't let them talk you into a trust.
There are a few other things on the screen as to when you may want to trust, and I'm sure Chris can
Yeah.
see that.
Yeah, and out-of-state property, blended family, special needs, and you can embed that kind of trust into a will. But if you have a child or a spouse who has special needs, physical disability, mental disability, those are good reasons for a trust. Not a U.S. citizen, great reason to have a trust. The estate tax rules kick in at $60,000, not $13 million, if you're not a citizen of the United States. Single parents, you should sometimes have them, especially if their children are minors, or if you have problem kids. You've got a kid with a drug or an alcohol problem, you might want to have a trust so somebody else is managing the money for them. You're not giving it to them to let them commit slow suicide, okay?
So trusts are unique and special, and you know, this is one of those situations where you can't handle it in a group. But we wanted to bring it to you in case you feel like maybe I need it, maybe I don't. This is a time when you talk to an attorney, right? So you'll hear that a lot.
Yeah.
If you think you have kind of that special issue, you know, then feel free to call. You have our information. We're going to
Yeah, we do need to. One other question that was asked at the beginning I do want to address, that's Medicaid. In every state, Medicaid rules are a little different. In Texas, if you have to go into a nursing home, the federal government is going to take everything that you have, except your house, if it's homestead, a couple $1,000 in the bank, and your car. Okay? And they're going to burn up everything else that you own to pay for that nursing home until you get down to that. Correct? It's not a good idea to sell your house in order to pay for Medicaid because that can possibly be preserved for your kids. If you own other property outside of homestead, they're going to make you sell it. You own additional cars, you're going to sell it. You're going to drain your bank accounts. Okay? It is possible, and it's getting too deep in the rabbit hole, but if you make enough money to kind of survive, but not enough to pay for a nursing home, which is at least $5,000 a month in Bastrop, Texas, right now, then you're in a bigger world of hurt because you're making too much to get Medicaid, but not enough to pay for the nursing home. You have to plan for that at least 5 years before you need it, because otherwise they're going to do what's called clawback, and they're going to make you either wait or they're going to start taking assets before then. If you can start that plan at least 5 years before you need it, then I can do a lot to help you preserve your estate.
If you put your house into the trust, you can't claim homestead.
That's right. You lose your homestead.
Well, that's not true. You can claim homestead. You're going to lose homestead. You reapply for it, they give it back. So you don't lose it for any length of time. You just have to get reapplied if the house is put in the trust. Okay?
Oh, you can still put the house.
When it goes from Chris Kirby owning it to Chris Kirby's trust owning it, I'm going to lose my homestead exemption for about 2 days because in that time frame, I'm going to go to the CAD, I'm going to fill out an application for homestead naming my trust, and I'm going to get it back. Okay?
Under the trust name.
What?
Under the trust name.
Under the
yes.
trust name. Okay, to probate or not to probate?
I'm gonna do one quick.
Yes.
One of the biggest challenges we see is people who do have a trust fail to put things in it.
Right.
So
I have a neighbor who paid $10,000 for a trust. That's more than I charge. But it was one of these trust mills that you see on TV. So she got this big fancy book with all sorts of provisions, and it owned nothing. It did absolutely nothing for her because she had not transferred her home into it, had not transferred her other properties into it. It's an empty bucket. So please don't get a trust. And listen, the trust mill will charge you a fortune to do that, and then they'll say, good luck. And you have a useless document, we're still going to go through probate. Okay?
So you go through the CAD's instruction to the file.
You don't go through the CAD to transfer title, you do it by deed.
you got deeds.
Yeah. Okay, to probate or not to probate? After someone dies, you have 4 years to probate. If you don't do it in that time, then the will that they wrote is invalid. We can't use the will anymore. And then you're going to transfer the property basically like they had no will at all. Okay? And that's called intestate succession or statutory succession. And basically what it means is we're going to go by these big word, tiers of consanguinity, which means we're going to go look and see if there's a spouse. If it's the first spouse and there are no kids from another marriage, those are different rules. If there's no spouse, are there kids from your marriage? If there aren't any kids, we're going to start looking for parents and siblings, and then we're going to start looking for cousins. We're going to find somebody who gets that land. In Texas, the state does not take it unless there's nobody who claims it, okay? Now, where I grew up in Arkansas, started practicing there, you go 4 tiers of consanguinity in Arkansas. If you can't find anybody, the state gets it, okay? Not in Texas because of oil and gas. But we're going to go find somebody and split it up at the first tier where we can find somebody who's supposed to get it. So the moral of the story is, take the time to grieve and then probate your estate. If you come to me and we don't need to probate it, in other words, all you have to transfer is a house, then we can do something called muniment of title. It's much less expensive. Texas is great for that. Not all states have it. But the bottom line is, just because you're married doesn't mean that you own the house. Okay? When the spouse passes, especially if you have children from outside that marriage, without a will, you're now a co-owner of your house with your stepchildren, and you have a life estate in that house, but when you sell it, they're going to get half. Okay? Moral of the story there, get a will. And then go and see if you need to probate. You also need to probate for things like cars and bank accounts if the name is not on it. Probate's cheap and easy. And we don't even have to go to court to get it done.
Before we move on to probate, I'm gonna, talk about the pitfall real quick, which is oftentimes what we see happen is they'll wait and they don't probate the estate, and then they go, oh, what do we need? And now we're asking for witnesses, 2 people who knew them who are not in the line of succession.
If there's no will.
If there's no will.
Or if it's too late for the will.
And the older you get, the harder it is to find your parents' friends who are still alive and have known them for 10 years. Is that
At
right?
least 10 years, and know if they had children, if they've been married another time, if there's anybody that's other kids out there. There's a fairly tough hill to climb, especially for very old clients.
So you have time, but not too much time.
Right. Just a few other things that I just want you to think about. Non-probate assets are things like investment accounts, retirement accounts, things like that. Anything with a beneficiary named in them. They can be payment on death accounts or joint tenant right survivor accounts in banks. But there's various things that don't pass by probate that you do need to know about, think about, and plan for. The I love you drawer basically means once we put all this stuff together, I want you to keep your original documents in a safe deposit box because it doesn't burn. Anybody who lived through the big fire in 11 or 15 knows that the papers inside those safes didn't burn. They turned to ash, and they're useless, obviously. So keep things in a safe deposit box, but then keep a copy at home where whoever's looking will go and be able to find them. And then the tough conversations they're talking about in Egyptian.
No, I just get double feedback.
Getting feedback, sorry. Do you want to decide or do you want somebody else to decide? Because as I like to say, there is a plan for how your last days will be. And when you're gone, how your estate will be distributed. The question you must answer is whether that plan will be yours or the government's. There's not a third option. You're either going to figure it out and have the courage to do things that you need to do. And yes, it is an investment, or the government's going to make the decisions for you. And whether you love his politics or not, one of the favorite phrases I've ever heard was Ronald Reagan when he said, the most dangerous words in the English language are, I'm here from the government and I'm here to help you. So you need to make those decisions. I will also say to you that the vast majority of parents of young children don't get wills and these documents because they don't know who they want to raise their children. You have to make tough decisions about this kind of stuff because the way is disastrous, and that's what I see every day. Okay.
So you have the contact information, and just earlier there was a question about reviewing, if things change. Yes, if you are a parent of young children, periodically you are going to need to review your estate plan, just like you review your financial situations. And so, yes, you'll need to do that. What we want to move on to now is...
Let me answer one more quick question that was asked at the beginning about ladybird deeds. If all you have is personal property in a house, then you can avoid a lot of stuff by doing what's either called a transfer on death deed or a ladybird deed. A ladybird basically says, I'm giving the house to my kids right now, but they can't really own it until I die. Okay, transfer on death deed says, when I die, it goes to the kids. And it's a deed, every bit as valid as any other deed, okay? They're great. They're a great way to be able to transfer property while you're alive. And you can say, my wife and I, there are various permutations. But they're a great instrument that if all you have literally is the house, then it can be used almost like as a substitute for a last will and testament. We talked about Medicaid, we talked about trusts, estate tax, probate you had asked. Hopefully that answered the question.
Not really.
Okay.
Just the simple definition of probate.
Okay, yeah, thank you.
What that means.
So somebody dies, you bring me their last will and testament, and you bring their death certificate. I file those with the court with what's called a notice of probate, or an application of probate with a notice. I don't have to go to court to do that. I just send it in. Okay. Then what happens is they'll come back and they'll say, okay, cool, Chris, you're the executor of your mother's estate. You get letters testamentary or letters of administration based upon what we're doing that basically give you the power to go set up an estate account, bring all the money into that account, marshal all the resources, figure out what the deceased person had, and give it away to everybody that deceased person wanted to get. So, I divided into equal parts amongst my kids. You separate it all out. At the end of that time, you file what's called an inventory, appraisement, and list of claims. In the meantime, you file the thing in the paper that all of us have seen. Notice all the creditors in the estate of Chris Kirby. And if any creditors show up, medical bills, whatever, then the personal rep is going to pay them, okay? And at the end of that time, you file this inventory and that's done. But it's the legal way to be able to transfer title to real estate, title to cars, title to boats. It's the legal way to be able to distribute the money out of the bank or the jewelry and that kind of stuff. It's just that process that you use to do that. And I think those were all, did I miss any questions? We had at the beginning, I'll answer other questions as we go. Okay, cool. So we gave you that packet of information. Because we're giving you legally executed documents, that means that you're a client, at least for tonight. And so the first one is that intake form that we'll need for, and please fill it out legibly if you want us to do these, with your name and your street address, city and state, of course, what your preferred phone is, and let us know what that is, and an email address that we can actually read.
Yeah, didn't sell that.
We don't sell anything.
We're not gonna
Trust me.
even use it.
I'm so technologically inept, there's no way I'd be able to figure out how to do that.
There are a lot of rules around it that pertain only to attorneys and law firms. And so we have to do this because those are rules required for
Yeah.
us.
And one of those rules is that because I'm doing this for you as a client, I'm legally prohibited from telling anybody that you're even a client, except obviously people in the room who figured it out.
Yeah.
So fill that out. And then after you do that, the second document to file is an engagement agreement because you're engaging us to help you do the medical power of attorney and the HIPAA release.
And you initial, if you already have one, if you already have a HIPAA or a medical power of attorney, or you have one and not the other, just initial beside the one that you're having us do, or both. And those are the only things that we are doing for you. That's why it's typed in there.
Generally, these forms, is it hourly rate or like?
It's a great question. So
For us, I can tell you for our firm, every attorney is different, every law firm is different. For our firm, this is a package deal usually, and it's a flat rate. It's flat for if you need the entire package or if you need per document.
What's the our document?
Well, it depends on your particular situation, so it's hard to, so generally speaking, those ancillary documents are about $150 a piece. But say someone who doesn't have minor children, they don't need the declaration of guardianship for a minor child, so they're not going to need the same thing that you need. And so that's hard to give you an exact quote.
And then the other big variable is what sort of last will and testament and or trust you need. It's going to vary those costs. So typically to do the whole thing with my firm, last will and testament, durable power, medical power, directive to physicians, HIPAA release, declaration of guardianship, for you and for your spouse would be about $3,000.
you do a intake first and to see where these are?
Yes. Yeah,
We have
typically,
we
yeah.
have a consult fee for that.
Go ahead.
So we have a consult fee, which is a little bit less, usually our consult fee is $200. And that's where we kind of assess what you need. And you meet with the attorney and kind of figures out what you need and talk it over and make the plan.
So as you're filling out that, that intake form, on the engagement agreement, you'll see, on page 1 that fill in your name and if you're here with your spouse, put in both names.
I
Well-
think I did it separately so that we didn't have that issue.
Oh, so we got, no, so just fill in
I
your.
gave one to every person.
Okay, both of you will fill out your own, and then initial medical or the HIPAA. And then when you go to page 5, you'll sign and date there.
So on the
The one that says that is this, Bastrop Law Group, County and Levy, you'll fill in your name on the first line.
I think
Just your name, and your husband will fill in just his name on his. And then you'll initial one.
and you'll notice all the fees, everything says NA. So it's good you guys are
Yeah,
getting this for
there goes
free.
fees.
Do we have to fill out like a legal name? Or?
No, just however you normally sign.
Yeah.
And then you'll see on the back page of that engagement agreement, this, sign however you normally do. I don't have to sign Christopher Winfield Kirby Senior. I just sign Chris Kirby. Okay. And then,
Ooh, I forgot to add the senior one.
yeah, that's right. Don't worry, she puts captain voice on. I get the message.
And again, this is another one of those documents because of our state bar rules that we're having you fill out. We're not going to send you anything.
So that we can give you these other documents. Once you're done with that one, I don't want to get too quick, but I want to get you over the medical power. You will, on this one, after the word I, put your name at the top.